Welcome everyone to today's class. This will be a value-packed presentation from folks who've been in the business for a number of years. I'm happy to moderate and kind of help guide the process. We're going to talk about best practices when we're working with sellers with respect to our listings and maybe some of the documentation and things you need to think about when you're working with sellers. And then we will transition into working with buyers, not just from a buyer broker agreement standpoint, but things you need to consider when you're submitting your offers. So Amy and Nick have both sort of provided their outlines that cover a variety of topics, again, as folks who are in the business. In addition to the antitrust disclosure, I do want to say that this is good information for you to know how to best use the NABOR forms in your practice, but we are going to give that a little disclaimer to follow your broker's guidelines. If your broker has a particular way that they would like you to address certain items, please, by all means, follow your broker's guidelines, but we don't want to make sure that you are aware of some of the tools that are available and some of the issues that are happening in our local market so you can, again, best utilize those forms. One of the things before we even get started, I do want to make you aware of a resource that is available at NABOR. And if some folks didn't know that there is a NABOR legal hotline that is available to real estate agents with the purpose of explaining which forms are available. So we will go into sort of the NABOR contract database. And if you describe the scenario, we say, of course, yes, we have a form for that. We have an addendum for that. We have this is the line in the listing agreement that answers your, sort of answers your question. If you call NABOR and ask to speak to someone in the legal hotline, an attorney member will give you a call back, or you can call the attorney member directly. And again, they're going to answer forms related questions. We're not going to give specific legal advice in a particular transaction, but we are going to help you. We're a resource for you as a real estate agent to understand where to find the information in these particular forms. Similarly, you know that Florida Realtors has its own legal hotline to answer questions related to Florida Realtors and Florida Bar forms. So I would encourage you to use those resources that are available. In addition, Florida Realtors legal hotline will answer questions regarding like licensing laws and things like that. I will drop their contact information also in the chat just so you have it handy. After we finish our presentation today, we'll send a recap email to Jeanette and she can circulate it to you with sort of a handout checklist guideline that will recap what we talk about today and also maybe help you in your future transactions. And we'll have some clickable links to some resources that are available at NABOR. So without further delay, we're going to talk first about best practices for listings and working with sellers. So when we're working with our sellers, Amy, do you want to talk a little bit about maybe how to identify the seller, how to maybe avoid fraud, that kind of thing, sort of that very preliminary, you get a phone call from someone and they say, I'd like you to help me sell my home. What are some things that you're concerned about?
Well, and one of the things, especially too, when you get those text messages or those WhatsApp, um, or just that I'm looking for a 4-bedroom, 2-bath. Are you an agent in Naples? You really have to be very, very careful. And they're even getting so crafty where you can actually receive leads on realtor.com and it's fraudulent. And so when you first get that contact, it's very important that you know where they found you, how they found you, because there's so many of us here. And even depending, no matter what they give you as far as information, we have to take and be very diligent. You're going to find a lot of times when you do have a fraudulent buyer, they're not going to want to take and ever be seen because everything can be done online. And so if you really want to make sure they're them, try to get them involved in a Zoom call. And, for agents, it's very easy. You don't have to pay for a Zoom account. You can get a 45-minute meeting, so you can set up a Zoom account for yourself for free and have that face to face. And you got to keep in mind too, people can still be crafty as far as that is concerned because of all the artificial intelligence. But looking at them, looking at them on forewarn to see if the person truly is a valid phone number. Looking at also the deed because you want to see that information too, because a lot of times, since that information is available on the public records, people are crafty enough to look for that. But I have had experiences where they spell names wrong and they do different things. And so they'll, it's just a lot of investigation work beforehand. And I think that what you're looking at is, just simply getting a copy of their driver's license or passport is just not enough. And I have dealt with several fraudulent dealings myself. And I will tell you, one of the big things for me is if something's wrong with the gut and it's not feeling right, it truly is not right.
Yeah.
So, Nick, what about you?
No, I think you definitely hit it on the nail on the head there. I think, touching a little bit more on the forewarn, just making sure all of our members know that forewarn is a free Florida Realtor member app that you can download on your phone, and you can um, backtrack, trace a phone number and verify that it is that person. And it's not going to grab every single number, unfortunately, but it does grab a lot of them. And you can verify that it is the right person. You can also see a little bit about their criminal history to make sure it's not somebody who has been in jail, just got out of jail type of thing. So it's definitely, before you really dive into the seller side, and also this definitely works on the buyer side as well before you show property. It's a good app, good tool to use in your repertoire for sure.
Yeah, yeah. And from speaking from the sort of the fraud perspective, we've heard a lot of terrible stories about vacant land fraud, right? So because someone's not living in the property, someone says, hey, I live in Canada, but I'm calling and I want you to sell my vacant property in Lehigh Acres. And I'm describing the property. No one's, of course, visiting the property. And without doing some extra due diligence by looking at forewarn, by maybe even sending a letter to the tax mailing address in Canada of the property owner to verify that, per our conversation last week, you wanted to engage my company to list the property, and including that information, please give me a call back with a code word, enter my broker name, for example. That type of information. We've caught some fraudulent sellers. The real owner of the property said, thank you for your letter. I'm absolutely not selling this property. Who are you? How did you find my information? And so we're able to catch that on the front end. And some of our title underwriters are actually requiring that, especially with vacant land. Amy, you brought up a good point about looking at the last deed of record. So what exactly am I looking at when I pull up that last deed from the property appraiser site? What information specifically am I looking at on that PDF?
Well, I want to see myself who owns it, how long they've owned it, if it's in a trust, if it's in an LLC, how it's titled. Because a lot of times too, when people are selling, if it isn't a trust, then I want to make sure that I get that information from the sellers, because you're going to need that at closing. So you have the right signatories and that you have all of that proper documentation. I want to see if maybe it was held in a life estate, because there's different types of life estates. And that's what I love about being able to have our members of our business partners who are attorneys that can help us with the closings, because they can review that to see whether or not, because not all type of life estates gives that seller the disposition rights to sell it. And so we really have to do that deeper dive into there. And then I also like to make sure too that when I look at if it's done in an LLC, and that I cross-reference that on Sunbiz to make sure that the LLC or whatever the agreement is active. Because if it's not, they're going to have to reactivate that. And I've had fraudulent LLCs created on a buyer side. So it's just really scary. And you need to find out that you have who is the registered agent and who has the signing authority on those documents.
Perfect. And specifically on the deed itself. So when you're looking at that last deed of record, you're looking to see who the grantee is. The grantee is the current owner of the property. So I'm just throwing that in there. Again, you're looking at the last deed of record, check for the grantee. And this is where sometimes we'll get pushback from real estate agents saying, no, I just look at the property appraiser site. It has it printed and typed up there, right? And you guys are shaking your head and you're like, that is a good start, but scroll down to the bottom, look where it says sales transactions, actually click on that hyperlink, because up will pop a PDF and you can confirm, because what you don't want to do is miss someone who was, is an owner of the property. And then all of a sudden you maybe don't have a valid listing agreement as to all unit, sellers or all unit owners of the property. Nick, what else do you do when you're sort of like deciding whether you want to work with a particular seller, what does that conversation look like about the process of getting them into a listing agreement? Once you've decided maybe that they are in fact the owner of the property, what are some things that you look for?
So definitely need to find out first and foremost is the first step is this is a condominium or is this a single family home? Because you're talking two different routes of contracts and of addendums and stuff that you're going to need. You're going to need every single property, no matter what you're selling, you're going to need the required flood insurance disclosure. Seller's disclosure statements, of course, are always highly beneficial. Not every broker requires them, but definitely beneficial there. And then from there, it needs to boil down to, the best way to look to see is it a condo or is it a single family home? Is look at the legal description. Legal description a lot of times will tell you if it says unit number or if it says condominium in the legal description, you're dealing with a condominium. And we're talking about the ownership rights, not the style, the building style and all that. We're talking about the ownership rights because that's all that matters, at least as far as this part goes. If it's a single family home, a lot of times it'll say either HO for homeowners, or it'll give you a lot number, which means that you're talking acreage of land of what you're owning. What lot number is that particular property is identified by? So once you know that, if it is a condominium, you're going to need your addendum to sales contract condominium that we created just recently. And because that basically, without that, you have a voidable contract on a sales contract if you don't have that. So it's good to get that filled out at the beginning with your seller because of those 3 new questions that are required by Florida statute now. And you can get those answered, have the seller get those answered so that you're ready when you do have a sales contract come in.
I love that you mentioned that. So, I started the question with, what do you think about at the time of listing? And you heard Nick say, well, you're going to need to know what to include in your sales contract. And I'm like, no, we're talking about the listing contract. But at the time of listing, it's the best time to have that conversation with your seller, especially if it is a condo, because there is a lot more information in 2025 that a listing agent is going to need to get to be able to sell that condo. And specifically, Tatiana, to answer your question, so specifically in NABOR, it's NABOR addendum to contract dash condo. That's all it says. It is a condo addendum. It is 3 pages now due to the disclosures that are required under Florida law. And so when you, again, you're welcome. At the time of listing, you're sort of thinking about who owns the property, what type of property we're selling, and then what documentation can I get at the time of listing that's going to make it seamless and smoother to get under contract with a buyer when there's a buyer's agent who brings along a buyer. And one of those things is the condo addendum. I know NABOR has offered a number of classes regarding selling condos, and we can kind of talk about that from a Q&A perspective, but identifying the type of property will help you understand what kind of additional disclosures can be completed or information that needs to be gathered from the seller's perspective very early on in the transaction. Because the worst thing, Nick, I'm sure you imagine, is you have a buyer who's ready to submit an offer on a condo or an offer on a single family home within an HOA and not having the addendum to attach the contract, the condo addendum or the HOA disclosure, and not having that information to be able to provide to the purchaser. So thinking of that from a listing perspective, you're having the conversation with the seller about the type of property and the process that they're going to need to go through. And with condos, there are some additional hoops that they're not going to need to go through, not in addition to that addendum. So what would you recommend for a listing agent who's, let's say, listing a condo? They know that they need the condo addendum, and it's just sort of a single standing condo building. What other types of documents might the listing agent want to start gathering at the time of listing rather than wait until contract execution?
So the other ones I look at is the age of the condo. Is it 1978 or prior? Because then you need to add your lead-based paint disclosure. And then also, is that condominium situated within a homeowners association? Pelican Bay, perfect example. Tons of condos in there. Pelican Bay itself is a homeowners association, even though the building itself is a condo. So you're going to need your HOA disclosure. And sometimes you need multiple HOA disclosures because you need one for each individual homeowner association. Sometimes you have a development. If it's a single family home, you might have your individual homeowner association plus a master association. So you do need the HOA disclosure for each individual homeowner association. Dealing with a condo, something like I said, Pelican Bay is a great example. Get your addendum to sales contract condominium. lead-based paint disclosure if it's necessary, prior to 78, but also that homeowner association disclosure very well could come into play, even though it is a condominium.
I love it.
Well, and we
Thank you.
also have
Yes.
we have community development districts. We have housing for older persons. Yeah, I think really what's a very good thing for associates to do, especially if they are specializing in one type of community or so, is to really take a deep dive into what they need and try to get a relationship with the property management company if you can, because it works so much better. And understand that if you can gather all of the documents that you need ahead of time and know who the association management company is, it's the seller's responsibility to have that. And the more stuff that we can have up front, so that when we get that offer and we know that all the correct documents are there, it's going to make it so much easier for both parties to have a smooth transaction instead of, to Nick's point, all of a sudden we don't have something. Now the deal can fall apart. And so I think our sellers would also appreciate the fact that we're forward thinking of, we want you to pre-sign these documents so they are available. And then even in your confidential comments on the MLS, indicate on there the type of contract you'd like to use, and to make sure that you're having the signed addendums that are in the supplement section submitted so that you fully have a complete offer.
Have those ready to go. Absolutely.
Yeah.
So say that again. So you, not only would you have these documents executed by the seller, or at least prepared, ready for execution by the seller, you're saying you would include them in the listing?
I
How
upload
do
them
you-
in the supplement section. Yeah. In the
Yeah.
supplement, Nick, I think it's what, 25, that it depends upon the size. I think it's 10
Yeah.
right now that you can
I think
upload.
it's
So
7 or
sometimes
10,
you might
some of
want to
that.
take several documents together, but I put all of the addenda that I need for a sales contract when in a particular type of community, I put those all in there, the seller's disclosure and everything, so that people are aware that they're there, and they can actually give that to the buyer. Because think about this, from a buyer standpoint, if they see what that seller's disclosure says and realizes that maybe, things are at the end of their useful life, and that they may think twice about what they want to offer. So it gives them a little bit of a heads up as to what
Yeah.
and how they might want to formulate that offer. So, I just love having that there.
Yeah, and plus, as the listing agent, if my seller has disclosed a defect to the property, I do want the buyer to sign that disclosure with their offer. So that way, I'm disclosing to them up in advance of them making the offer. Plus, when it comes time for the inspection, the inspector says, well, this is defective. The buyer doesn't have the right to ask the seller to fix it or credit, because it's already been disclosed to them. So it's like you said, just the transparency of it, just get it out in the open, let everybody know what is there to deal with.
So I want to, Nick, I appreciate that point, and Amy as well, of just the ease of having the information uploaded into MLS and making sure that it is available. And then you put the note in confidential remarks to let the buyer's agent know, hey,
Yes.
here's where you can find the information, pull up this information here. And I would say the cautionary tale I'd say is to make sure that that information is still accurate at the time you go under contract. So think about your properties that you've had listed just before the holidays. After the holidays, maybe the budget has changed, and so the fees might be a little bit different than they were on the disclosure. So gather at the beginning, upload it on MLS, but be prepared to update it as needed before you go under contract. Nick, about the seller's disclosure. Oh, yeah,
On
go
the
ahead.
seller's disclosure, to your point, it's one thing with the budgets, but when we have a hurricane and there could be damage, it's really important that if your seller has had damage, that they update that seller's disclosure so that you can have that information all current.
Yes, agreed. And yes, so let's talk about that seller's disclosure form. Specifically, we're talking about the NABOR version of the seller's disclosure. Nick mentioned if the seller discloses something that would normally be deemed to be defective under the sales contract, under the standard NABOR sales contract, the seller discloses it on the seller's disclosure, and the buyer signs the acknowledgement of that receipt of that seller's disclosure prior to or at the time of contract execution. Whatever is disclosed as defective is not going to be deemed defective under the sales contract. So there's no, there's certainly a benefit to a seller to disclosing all the information and a buyer acknowledging receipt, because presumably when the buyer acknowledges they've received the seller's disclosure, they're going to make their offer based on that information.
Correct. Yes.
That is assuming we're using a standard NABOR sales contract. So just keep in mind, if the buyer submits a NABOR as is contract, there is no such thing as defective or not defective under an as is contract. So there may still be a negotiated item, even if it was disclosed in the seller's disclosure. And you're right, your brokers may have an obligation for you to have a seller's disclosure on file. Some brokers have a policy of not requiring it, but there's certainly a benefit to a seller to disclosing all of the information, having the buyer sign off at the very beginning. You guys mentioned a flood disclosure. When do we need a flood disclosure?
Always.
Always, every property,
Always. Yeah.
every single
Always,
property,
everything.
condos, single family homes, doesn't matter.
So every single residential property requires a flood disclosure. And what are the two questions that the flood disclosure asks? Not to put you guys on the spot, but I'm gonna. What are the essentially?
basically
What are
have
we
you-
trying to find out?
If you have filed the claim, or if you have
Received
any
funding,
kind of
federal
standing
funding.
water, I'm thinking about that.
Yeah.
Or
Yeah,
if you've
so-
had relief.
Yep. So
Yeah, if you've had
the
funding.
law now requires a seller to disclose if they have filed an insurance claim, an NFIP type of insurance claim, or if they've received FEMA funds related to an inundation, a flood, water coming from the outside to the inside. That is what the seller is required by law to disclose on that flood disclosure.
Yeah.
The flood disclosure is not an addendum to contract, just like the seller's just regular disclosure.
Just a disclosure.
Not
yes.
an addendum, is just a disclosure, but it is required for residential.
So it's a good point, Erin. So in the field, I've had offers come in where, on the sales contract, under those addendums, they'll add seller's disclosure, they'll add the required flood disclosure. You don't need to add anything about those on the contract. Those are just disclosures. That's why we don't have them listed in those addendums, because they're not addendums. So just keep that in mind on that other blank space. You don't need to put those in there.
Correct. Yes, very good. So just a point about contract execution. When we're talking about this universe of forms, we're talking about the NABOR forms. Do y'all hear an echo?
I do.
Okay, let me see if we can figure that out. I hear an echo, but I didn't know if it was just my connection.
Please,
Don't know.
someone's unmuted.
I just muted it. I don't know who it is, but I just muted him.
Oh,
Can
perfect.
you guys still hear me okay? Okay. So
Yes.
the difference between a disclosure or an addendum to attach to the sales contract. When we're talking about the NABOR universe of forms, we know our general rule is to not mix NABOR forms with FAR forms with FAR forms. We're not mixing those contractual forms in the body of our sales contract. And there's some documents, if you look at the checkbox paragraph at the end of the sales contract, paragraph 19, I believe, there is the complete list of all of the addendum that NABOR has contemplated to be potentially attached to the sales contract. And then there is a line for other. And if there is an other addendum, I'm imagining that being an addendum prepared by counsel, potentially
Correct.
to attach to the sales contract that doesn't neatly fit within, within the other disclosures. We know that NABOR has a blank addendum to contract, and Nick knows that blank addenda or blank amendments give attorneys heartburn just a little bit. We get a little bit nervous when agents are drafting some legalese.
Some brokers too.
Brokers too, yeah.
Some
So
brokers too.
if you have a buyer who wants some specific language included in their contract, at the very least have it approved by your broker, preferably approved by the buyer and or seller's attorney before you draft that language. You just want to make sure that it is clear and concise and it meets both parties' expectations. And this, of course, will prevent some litigation down the line, or at least that's the hope. So when we're talking about the NABOR contract, we're talking about the addenda that we can attach or the disclosures that should be provided to a buyer prior to contract execution. The other disclosure you mentioned was the HOA disclosure, the homeowners association disclosure, which is required for every mandatory HOA. So every mandatory community association governed by Chapter 720, a seller is required to provide it to a buyer. A buyer is entitled to receive that HOA disclosure prior to contract execution. And the reason we want to make sure that that is uploaded in MLS, complete and accurate as to the name of the association and the amount of regular assessments and special assessments and land use fees. So we want to make sure that it's complete and accurate and provided to the buyer prior to contract execution, or at least at the time, the buyer submitting the offer, they've already signed this HOA disclosure form. Why is that so important that I keep saying prior to contract execution? Amy, Nick?
So, but
Because if they don't, okay, go ahead, Nick.
no, I was
Yeah.
gonna say, basically, if it's similar to a condo, you have a 3-day right of rescission from the time you receive all the documents and stuff like that with required by Florida statute. On a homeowner association, if you provide that disclosure to the buyer, then in a sense, they're waiving their 3-day rescission to receive all of the HOA documents, which includes all the, the declarations, the covenants, the bylaws, the articles, everything. So you're disclosing what the HOA fees are to them and any assessments out there. And that's what saves you that 3-day rescission period. We also have, there are some buyers who want to receive all that information. They want to review it, and that's fine. We have an addendum for homeowner review. So if your buyer is the attorney or the type that really wants to read everything about what they're buying and where they're buying, it makes sure you include the addendum to sales contract, homeowner docu review. And so that way the buyer is not waiving their 3-day rescission by signing the HOA disclosure. And then the seller will need to provide all those documentations to the buyer for their 3 business day review period.
So I'd say even if you are using the HOA document review addendum that allows the buyer to request from the seller all of the documentation, declaration of covenants and restrictions, they also need that HOA disclosure summary form to be completed and prepared and accurate from the seller. But you're right, the way that a buyer can get those HOA documents from the seller and require it from a contractual standpoint is to make it an addendum to the contract. HOA disclosure or HOA document review addendum makes the buyer be able to request it and have a review period. The HOA disclosure summary, you hit that nail on the head. Also, the HOA disclosure summary that is required by statute. If a buyer does not receive it prior to contract execution, then the buyer has a 3-day right of rescission after receipt. And we don't want our buyers to have an unnecessary right of rescission when it could be preventable. Amy, I think I cut you off. What were you going to say?
And one of the things we have to make sure, the sellers are the ones that are writing the check to the HOA. They know what it is. So they need to give us that information. They need to fill it out. Don't look at the previous MLS's information because you don't know if there has been changes in the budgetary thing. Because if that's wrong, that could be an out for them. I mean, and if you have somebody who's really looking to get out of something, they're going to try to use anything they can. So please make sure your sellers are giving you that financial obligation information.
Yes.
Good point, Amy. One thing, if you don't learn anything today, do not look at other supplements on MLS of other listings, of other prior listings, and assume that they are accurate. Have your seller get you the correct information.
So that was sort of answering the question of someone in the chat. They said, how would we know if there are multiple associations if the seller is not sure? So one of the things I would ask is, well, where are you making the check? Who are you making the check payable to? And they give you a name of a property management company. Contact the property management company and say, which associations are pertinent to this particular property. Is there another association? Is there a master association? Sort of get that information from the property management company if the seller doesn't know. They should know though. They're charged with having this information and being required to provide it to the purchaser and accurately disclose it. So I'm giggling at Sam's response to another question. So the question was, do you think NABOR will do away with the NABOR forms and go to Florida Realtors forms? Sam Sod says, hopefully no. You never know. But NABOR does have, we're in our own unique bubble in Southwest Florida where we use standard sales contracts where the buyer is making a request for repairs, sellers either agreeing to the request or countering, and the buyer has the right to terminate. That is a different process here in Southwest Florida versus the rest of the state that uses primarily as-is contracts. The Farber as-is contract is the same thing.
And keep in mind, NABOR forms were created before Florida Realtor forms were created. So we have been around about 8 to 10 years longer than Florida Realtors has. So
That is true. That is true. Um,
One of the things I also want to point out, because I didn't mention this before, but a lot of times we find that we have individuals who have power of attorney
okay.
to act
Yeah.
on behalf of the seller, but not all power of attorneys give the right of the person who has that power to dispose of the property. So we've got to make sure we get copies of that to find out again who would have the signing rights. And then also remember that if during your transaction that individual passes away, the power of attorney is no longer valid because they have no power over anybody because they're deceased. So you really have to have a good understanding about what's happening with the situation with your sellers so that you know what could potentially happen, because if all of a sudden now you're under contract and now the person passes away, boom, you've got a whole nother issue there.
So would you, let's say that someone approaches you to say, like, I've inherited this property, or, you know, so-and-so is deceased and I'm handling the estate for the family. What type of questions might you ask? What type of information might you want to gather? And is there anything that you could do from a sort of a preliminary standpoint that falls outside of the scope of a real estate agent, but maybe to find out what liens might exist on the property or what additional documentation might be required from a probate standpoint?
Well, I want to find out if it's actually even started the probate process
Yes.
because we don't know. If we're looking for a letter of administration, who's the personal representative, if there's been a determination of homestead, and all of these things do get recorded with the county as they're processing. However, we don't have, as real estate associates, we don't have access because it says confidential. So we have to rely on either the sellers to get us that information or be able to work with one of our attorneys to be able to get a true copy of that so that we have that in the file. Because if something has not cleared probate, and you know, with the whole process, you've got the 90 days for them to search the liens and all that out, it could really extend what the time period is on that closing. And if the sellers gives you that information and you can at least let the buyer's agent know that there could be an extension that needs to be done so that they know that they're looking at the right properties, because it could take months
Yeah.
to actually
Oh,
go
yeah.
through the process, and I've had it happen to me.
And I would even encourage folks in that type of situation to go ahead and talk to your favorite closing agent, title agent, law firm, and have them pull a preliminary title search to see what exists in the property, to kind of find out what transactional hurdles, title defect hurdles might need to be cleared. And then that way they can coordinate with a probate attorney to be able to address those issues before you're in a 30-day closing or 25-day closing time crunch. So again, that is an opportunity, and not a lot of folks take advantage of that opportunity of getting a prelim title search. But it's worth having the conversation. Maybe not for every closing, but certainly in the event of a probate, when you need to figure out, you know, a little bit more. Anytime there are deceased folks entitled to the property, you need to do a little bit more digging. And good point regarding the letters of administration. And you mentioned that POA dies with the principal. So if so-and-so comes to you and say, my aunt passed away, I was the power of attorney, I want to sell the property, red flag, we pause. Someone who's deceased doesn't have the authority to give another agency over them. So they know that the POA is good while the person is alive. It needs to be reviewed by counsel to make sure it gives the agent the authority to do whatever it is you're asking them to do: sell the property, convey the property, mortgage the property if it's a refi. Make sure it's reviewed by counsel. And again, if the person dies, the POA is no longer valid. Yep. Nick, so you started going down the line of talking about a condo. This is the type of information you might need for a condo. Is there any type of different information that you would want for a single family home besides the HOA, specific disclosures, or anything else you might ask?
I'd say the only other thing on, at least on the condo side, is once you, with the seller, you want to have that addendum filled out by them. It does have those 3 questions on there to make sure that they get those answered. But then you want to go ahead and at the listing, go ahead and get the documents. Have the seller request them from the property manager if that's what it takes. But make sure you get your declaration, the articles, the bylaws. You should already have a governance form. Make sure you have the most recent one, the 20, I think it's 2021,
2021.
2022.
Yes.
Make sure you have that one. Somebody sent me about 2 months ago, sent me a 2009 version, and I had to let them know that we have an updated one.
Me too.
The condo question, the Q&A or the frequently asked questions, get their budget. The most recent annual financial statement is required now. The rules and regulations, get all these things. And of course, now, if the property applies, you might have a milestone inspection report, the STRS, the structural integrity, turnover inspection if it's a new community since 2003, but get all that stuff, have it ready. I don't put those up into the supplements. I know some agents do. I keep those in a file, ready to go. Once it goes on a contract, then I send everything to the buyer's agent on those. And the reason I don't put them up in the supplements is because I'm afraid agents will take them and use them, a year down the road, and now they're giving old information, old rules, old budgets, and so I just keep those off of there. I just put up the disclosures that I need the buyers to sign with the sales contracts there. But stepping back over to the HOA as well as with the condo, here comes our favorite one is going to be, do you need depending on your listing contract, do you need a BCA? Which everyone knows that the BCA we short for is the broker compensation agreement. And if your seller elects to offer compensation to a buyer's broker, it's best to go ahead and get the BCA, the broker compensation agreement, filled out right then and there. Have it with your sales contract, or pardon me, your listing contract, so that you can have it ready to go. You cannot put that on the supplements to MLS, but you can have it in your file so that if an agent is showing and they ask what it is, or they ask, they're ready to put an offer in, you can email that to them. In your listing contract, if the seller is providing compensation to a buyer's broker, you will need the buyer broker compensation agreement, listing broker to buyer broker. Again, listing broker to buyer broker. If the seller is not offering compensation and down the road an offer comes in and they want the seller to pay, if the seller agrees to it, that's where you could end up having the BCA for the seller to buyer broker. Again, you don't want to mix those two, because if your listing contract is already stipulating a specific amount that's paid to the buyer's broker, you don't want the seller to get locked into paying a seller to buyer broker as well, because now you're doubling up on the commission and it's going to cost your seller potentially, and that's the last thing you want. But if you have the BCA signed, get it taken care of right then and there with your listing. Shortly thereafter, the day after listing is fine, but have that form ready to go. And that way, it's, again, if an agent is wanting to make an offer, you can send that to them, and it's the contractual obligation of a listing broker to pay the buyer broker compensation with the seller and the buyer listed on that form. So that way, it's taken care of for you that way.
So I want to stay with this topic, and I'm going to answer Tatiana's question. The question was, what is the agreement? It's a broker compensation agreement. I think we've called it seller's broker to buyer's broker. I'll confirm
Yeah,
that. in just a
so
second.
there's two BCAs. And we use acronyms all the time, especially in legal resources. The BBA is the buyer broker agreement, the BCA is the broker compensation agreement.
Yep.
But the broker compensation agreement, there's two forms. One is the seller to buyer's broker, where the seller is paying the buyer broker directly, not through the listing agent, directly from seller to buyer broker. And then the second one is going to be the most common for everyone, which is the listing broker to buyer broker. That's the one that's very similar to how we used to do business. Seller was paying compensation to the listing broker. Part of that compensation identified in the listing contract was set to go to a buyer broker in the event of a successful sale. Prior to our MLS, when you agreed to the MLS rules, you agreed to cooperate. That changed August 17th. Legal resources, we had to create a new form of some form of an agreement that now stated, listing broker was going to be paying a buyer broker. That's what this form does. It's now the contractual agreement for the listing broker to pay the buyer broker based on what their listing contract states.
So again, you're mentioning this as a form that would be good to get at the time of listing. Why get it at the time of listing? Why not just wait till an offer comes in?
Because if you have multiple listings, sometimes you might get them confused. Sometimes you have to go back and check your listing contract and stuff like that, and then get it filled out and done. This way you have it, it's in your file ready to go. So if an agent's showing the property, they can either, if they're asking what the compensation is, it's, if there is, or whatever it is, it could alter how the buyer makes their offer or what their offer is. So if you have this form ready to go and you can send it to the agent when they're making their offer, sometimes you don't even have to deal with the compensation all with the contract. You've got it taken care of out with that form. So it's almost just like the MLS was.
I agree. I agree. Amy, any tips on the broker compensation agreement or how the listing agreement interplays with that, the sort of the new
Well, and I
requirements?
think, when you're filling out your listing agreement, you're having that conversation with the seller as to what your amounts are, what you're offering out, if they're not off. So you already know all of that. So there's nothing that would prohibit you from getting, to Nick's point, the BCAs taken care of, because you're already under that contractual obligation with the seller that you're going to offer out this amount. So it just is transparency, and it's just, we're all busy, we're all crazy, and sometimes we just can't, especially when you're having a lot, to Nick's point, you have a lot of listings going on. It's just nice to be proactive in getting everything that you have ahead of time. And to that point, before I forget, we're talking about contracts and that, but when I'm at listings too, I want to see if they have a copy of the deed. I want to see if they have a flood certificate, their survey, their current flood insurance, because if they have that, that could actually give the buyer a discount if they could do a declaration page. And then look at the oh my gosh, I just forgot. The survey elevation certificate, and that, try to get as much as you can up front, because in some instances you may get a little bit of a better thing. The title insurance already has a lot of information that will help the closing agents.
Yes.
So I like to get as
That's
much as I
100%.
can. Yeah, and I prepare them for that, saying, when I'm coming over, please make sure you have all of this available for me, because they may have to find it.
Yes. Yeah, absolutely. And yeah, as you mentioned, if the seller has a prior survey and they haven't made any changes to the property since the date of the survey, there's a contractual requirement both under NABOR and FARBAR that the seller sign an affidavit at closing confirming that. And so the seller's got to produce the survey if they have it. If they haven't made any changes, then they're going to be signing a survey affidavit. And the title company or law firm will prepare that affidavit for the parties at closing. So having all that material, again, title policy, survey. If the title policy was issued within the last 3 years, there's going to be a discount on that policy. So if you're in Bonita North and maybe the seller agrees to pay for the buyer's the owner's title policy in their sale, having that prior policy is going to be helpful. And if it's at a discounted amount, that's very helpful for the seller. You mentioned elevation certificate. Homeowners insurance. How many of you have had buyers who've had a concern about being able to afford homeowners insurance or flood insurance or being able to bind homeowners insurance? So while it's not a contractual requirement that the seller give that information, it's good to be able to provide to the buyer's agent or the buyer that this particular homeowners insurance provider is insuring this particular property, and you're able to give that information. And if in the event of flood insurance, there is an opportunity for the buyer to assume that flood insurance policy or transfer that flood insurance policy prior to or at the time of closing. After closing, it's going to be too late. So asking those questions up front. Okay, bear with me just a second. So I'm just on the topic of buyer broker agreement. Wendy, let's get to answer your question when we flip over to buyers, which will be very shortly. But I promise we'll come back to that question. So in addition to your listing agreement, we've already identified a number of items that the seller should have handy, documents that are from their previous transaction that would be helpful. The disclosure information, flood disclosure, seller's disclosure, homeowners association disclosure forms, the addenda that would eventually be attached to your sales contract. Those addenda can be used, prepared by the seller with the information that only the seller knows, and given to the buyer's agent or uploaded into the supplements in MLS to be able to provide to the buyer. I just want to pause for just a second because we did talk about broker compensation agreements, and just remind everyone that we are not including broker compensation agreements or anything with respect to compensation in MLS. So you can have those forms completed, but saved on your desktop, saved in a
Do
folder.
not
but
upload them into supplements.
You're not uploading them to supplements. You're not putting any comments in, broker remarks or anything with respect to compensation in that. But can have the form completed. Just don't include it in MLS. We're avoiding that from MLS. I think there was one more thing I wanted to touch on from the seller's perspective. Oh, yes. Okay. This one I'm going to talk about. So if you are selling, for example, a condo and you have the listing, how many, is anyone on the Zoom, you can reply in the chat, how many of you are getting that condo pre-approved for financing, or to find out whether there is financing, what type of financing might be available for this particular condo building? Is anyone doing that yet in this market? Especially if you have a condo right now, I think it'd be very helpful to your sellers to have a conversation with your lender partners, provide the information that they request to find out what type of financing the condo building qualifies for. And here's why. The worst thing, and I would say the worst thing is to have the property off the market with a buyer who could never buy the house, right? Who can't purchase the property. Maybe they individually qualify, but the building itself doesn't qualify for a particular type of financing. So what I've heard more often than not is a buyer goes under contract, they need 95% financing. Seller agrees. They're like, great, I will accept a financing contingency with 95% financing. They go through the process. The property is taken off the market. The buyer goes through the process. The buyer themselves are, in a great position to purchase the property. But then they find out that the condo is unwarrantable. And the lender says, well, we can proceed with a 75% loan to value ratio, but the buyer needs 95%. So now we are 30 to 45 days into the transaction and find out that the building itself doesn't qualify for the type of financing the buyer is seeking or the buyer needs. You have to list the property again. You've got to do more open houses. You've got to start all over with a new purchaser, and you've got a frustrated seller. You've got a buyer who spent money on inspections, spent money on appraisals, and they're not going to get that money back. And that's not a great scenario, right? So especially if it's going to be more challenging to sell condos, my suggestion would be, if you've got the listing, contact your favorite lender partner, give them the information that they need to be able to see what kind of financing is available for the particular unit, and then use that information to market it. So if you find out that this is Fannie and Freddie approved, put that information, make sure you're getting it from a reputable source, but put that information in your marketing, put it in broker remarks so that the buyer's agent, who knows that their buyer requires 90% financing, knows that this condo is something that they would be eligible to purchase. Likewise, if it is not a warrantable condo, then you can say it in a positive note that this building it only has a maximum of 75% financing due to too many investors, or due to whatever the issue is. That way, again, you're never wasting time off market with a buyer who could never close or would never be required to close because of their financing contingency. And again, it's a shift in mindset from thinking of financing as a buyer's problem, a buyer's issue, but really you want to make sure, especially when you're selling a condo, that you're not putting a buyer under contract or removing the property from, as pending with contingencies, only to find out that due to no fault of the buyer, the building itself didn't qualify for the type of financing that was listed in their contract. So the couple of things that the lender will need is a copy of the master insurance policies and all policies related to the external structure. They'll likely require a copy of the budget, any information regarding litigation, any information you can provide to the lender would be helpful. But those things the seller can help give to you to provide to the lender partner, and then they can do some research, and then that way what kind of financing that building would qualify for. So I hope to see a little bit more of that.
To that point, Erin,
yeah,
a lot of times that's probably one of the good places to be able to go back into closed sales and see, is everything in that condo unit cash, or have they had conventional, or have they had potentially FHA or VA financing? And I myself have called the listing agent to ask who was the lender so that I can find out, because maybe there's already that condo questionnaire. Now, not that they can use that for the next individual, especially if there's a different lender, but at least you have a better understanding that that condo has gone through recently that condo questionnaire process, and maybe that's a good way to build your relationship with a new a business partner for that. But if you see that everything is cash, then that could be a bit of a red flag for you also.
Sure. Absolutely. I'm going to answer some of these questions in the chat before we switch over to buyers. So yeah, building review for funding. Yes. Yep. So PG, we're going to put together a sort of a recap of the things we talked about. And yes, we'll make it in the form of a checklist. If you're selling a condo versus selling in a homeowners association, the information you're going to need upfront from a disclosure, condo or contract addendum standpoint, and then also just some additional information that would be helpful to a buyer's agent. Tony, is it enough to have the documents on MLS, or does the buyer need to have the documents handed to them? Good question. Is it enough for it just to be an MLS and we never know if the buyer gets it?
Nope.
All right, you gotta give them to the agent.
Yeah, because they have to be signed and put to be part of the sales offer. So you have to make sure that you're having all of those documents, the HOA, the condo, all of that, all the addendums with the purchase agreement, so that everything is signed. Because if you don't have a fully executed contract.
Correct, or at least one that incorporates those addenda. And Tony, if you're asking, do the condo documents, is it sufficient that they are just an MLS, or do you need to know that they are, given to the buyer? They must be given to the buyer. So the statute actually says buyers entitled to receive this information, and our condo addendum, now it's very clear, it says seller shall provide. So just putting it on MLS is a good place to start, but make sure the buyer receives all 7 pieces of information when you're dealing with condos, plus the answers to those questions related to milestone inspection, structural integrity reserve studies, and the turnover report for turnovers after July 1st, 2023. Gina's question, are we representing the buyer? If we're representing the buyer, are we talking with the lender also, or the seller's agent having trouble getting some of these basic disclosures? Bless, I know, Gina, it is hard to get some of the information that we need to be able to put together our contract. Let's assume for a second you mean the condo addendum. Your buyer wants to submit the offer, it's a condo, you are ready to submit the sales contract with the condo addendum, but the seller hasn't provided it, right? Or the disclosure information isn't complete. Maybe it wasn't uploaded on MLS. So in that instance, guys, what would you do if you know that your buyer wants to submit an offer, but they don't necessarily have all the information that they need from the seller to be able to submit an offer with the condo information? What would you do?
I've actually called the listing agent and asked them to provide it, get it signed. It's the seller's responsibility. And because sometimes they still don't know that this is a new form and a new requirement. Sure.
Yep.
And because I don't want to have present an offer without knowing, because we don't know what the fees and everything are. So I throw it back to the listing agent first and try to attempt it there.
Yep. Nick, same
thing. Yep.
Yeah.
And unfortunately, and I will say this, it's some sellers are having a hard time getting the information from the property management companies.
It's true.
It's happening. I would just say, just be diligent, keep asking. The management companies are going to be the ones to be able to provide the answers to the sellers, but it's just stay on them.
Yeah. And that's another reason why we want to get this information at the time of listing, rather than wait until you have, you've had the property listed for 3 months. And then on a Sunday morning, someone's trying to submit an offer to you and they ask you for the condo addendum. You say, oh, shoot, I don't have the answers to any of these questions. I don't have the condo docs. And then on Monday morning, you're contacting the property management company and you're scrambling to get the information that you had 3 months to get. So you did mention that yes, we're going to give our colleagues some grace a little bit, because this information is new as of January 1st this year. The condo addendum is new in NABOR land. These 3 disclosure questions are new, but to the extent we can, we want to make sure that our listing agents are on top of it. Our listing agents are getting this information. And if they don't know where to start, it's their first condo sale, or if they, just don't know what they're doing, we're going to help them because the idea is to get the transaction across the finish line. If you're a transaction broker, your goal, right, is to make sure the transaction is completed and finalized and closed. So whatever we have to do, I will say anecdotally, while we can say it's the seller's responsibility, that doesn't get us anywhere if their agent doesn't know where to get the information. So we can help them. We can help them help us help get the transaction across the finish line. But we can rely now on the language in the condo addendum, both in NABOR and FARBAR, that says it's a seller's responsibility. And we're just going to point it out and say, hey, this just, if your seller is resistant to giving this information, just know it is the seller's responsibility to provide it. All right. Are there any questions regarding the listing side or maybe some information you'd want up front? Otherwise, we're going to jump into best practices when working with our buyer friends. No questions in the thing? NABOR has an X form for the condo addendum. Sam, I'm not sure what you're saying. NABOR has a form.
I know what
Oh,
he's
okay.
saying because because the X form is the newer form, and it has the appropriate questions, where the one without the X does. So we have to make sure we have the most updated one. Hopefully people
Thank you.
realize that when you have app files, .loop, any of those programs that your brokerages use, that they have the most current forms on those programs. Please do not take and print out packages and stick them in your car so you have them available, because you may not have the most updated version. Go to your sites to be able to make sure that you have that form simplicity, whatever your brokerage firm wants you to use, because they have the most recent.
Absolutely.
And you can
And
always,
go ahead.
I'm
Sorry,
sorry,
Nick.
I was gonna say, you can always double verify that you have the correct form by going to nabor.com. Under the tools, the contracts are there. They get put there before they go out to any vendor. So you can always get the most recent form on nabor.com as well, or at least verify that it's the most recent.
Yes, that was exactly what I was going to say. NABOR.com folks might not know that they can find all of the NABOR forms on NABOR.com, realtor tools, and then contracts and forms, and the entire NABOR form library lives there. And that is where it is updated first. You can find the contract forms, addenda, amendments, listing agreements, buyer broker agreements, comp agreements, and then even some resources, meaning additional documentation that a buyer should receive at or prior to contract execution. Are there any that come to mind locally in Southwest Florida, that disclosures that need to be provided to a purchaser related to code enforcement or?
Well, we actually
Energy
have
efficiency.
3 different forms in our library. The contract says that we've given them the Collier County Code brochure,
Sure.
the equal housing brochure, and the energy efficiency brochure. The contract says the buyer acknowledges receipt, so we have to make sure that we get those to them.
Yep. And if you don't have them in your forms database, go to nabor.com and scroll down to the very bottom, and you can find those resources. They are available. All right. We're going to hop onto the buyer side. So let's say that you have a buyer that you're working with. We know that as of August 17th, 2024, you are working with a buyer with a buyer broker agreement. A buyer broker agreement or showing agreement is required with the buyer under the post NAR settlement. I just taught a 3-hour class on buyer broker agreements. So for me, it's all, old news as of this morning, but just make sure that you're having a conversation with your buyer. The idea of the buyer broker agreement is to get your buyer to agree to engage you for services and compensate you for those services prior to touring a property. That is the crux of the issue. Our buyers are going to negotiate compensation with us. We have to explain to our consumers that broker compensation is not set by law. It's fully negotiable, that I am agreeing to provide these particular services to you as a buyer, and you're agreeing to compensate me. That's it. Have you guys, since we're 7 months into this, have you encountered any pushback on buyer broker agreements or pushback on the type of agreements that you're using, specifically the NABOR forms? How do you get your buyer to agree? Because I've had some folks say, well, no buyer is going to agree to that, but there have been transactions that have happened in the last 7 months. So someone has agreed to something. So what is it that that has helped you work with buyers?
I'm probably not the best one. my business is all repeat referral, so I have not had any
Okay.
problems or issues or any of that
Okay.
with any of my, customers. It's like I said, I have the repeat referral, so I haven't had any issues with them, thankfully. So
So you've
but-
gotten the agreement signed, but they haven't pushed back because they already trust you
Yeah.
and they know you.
Correct.
Okay.
Mhm.
Okay.
Yeah.
Amy,
Right.
what about working
And
with
it-
strangers?
Yeah, and the thing is, at that point too, it's just something a little bit newer for them that we have to do. But I think this gives us a very good opportunity to be able to sit down with your buyer and truly conduct a buyer consultation session
Mhm.
and
Yeah.
know what their needs and wants are and be able to explain to them that, just because there is a buyer broker and you may have to pay. You may not, it depends. And we have to make sure that we understand what's going to be happening. And this is all about transparency. And so when we're able to also find out, well, what type of agreement, and you have to go back to your broker first to find out what type of agreements they want you to work with, because there's different ones that will do, you can just limit it to maybe one property, one type of community. Maybe you're going to do it for a week, for a day. So it is very important that, first of all, you understand whether or not you really want to work with this buyer, because it may not click. So maybe if you limit it to a certain few addresses, after that time, you can extend it. Versus, are you going to go into something for 3, 6 months, whatever, and then it's a nightmare. And so you really have to have a good understanding about what forms you want to use. And you have to show your value proposition to the buyer as to what you're doing for them through this. Everybody just thinks, okay, you know what? I'll just put in my car and I take. There's so much more, as I'm sure many on this call understand. There's so much more than just opening that door. And knowing that you are a resource to that buyer when they have all these different questions that are coming up, that you are going to be there for them through that whole transaction. Because at some point you want to be like Nick, and I do a lot of this myself. You want referral business. This business is about relationships. It's not about transactions. And so the more we can be that individual who's there for our buyers, the better we're going to be able to build that. And so look to see the different agreements that are available and find out what is the best one. Remember, you can always change it if you want to take and extend that time period that you're working with that buyer. Or maybe your broker will let you assign it to somebody else if that connection isn't there between you. Because remember, it's still between the buyer and the brokerage firm. It's not their committee, it's you and the brokerage, not just you and the agent when they're signing that buyer broker agreement.
Yeah, and I think, following up on what Amy said, it's the perfect time to have the conversation and really explain your value to the buyer. Explain to them everything you're going to be doing. I mean, there's a lot of work that the buyer side does. So it's a great opportunity to really, showcase that to the buyers and, show them your value, show them your worth. And I mean, I'm gonna say this now, but I don't want to get into detail because we're going to talk about it shortly. But there's two forms. As Amy said, the buyer may or may not have to pay that compensation. You know, the buyer broker agreement that we have at NABOR states that, the buyer's giving us authorization to try to have the seller pay that or other means of it. It's maybe not a bad idea to show the buyer our addendum to sales contract compensation, to show the buyer our addendum to sales contract concession. Those are two forms that you can put with your sales contract to have the seller or the listing broker, wherever it is, to pay that compensation that the buyer's agreeing to pay. So it's a good to have that conversation up front. And again, we'll get into more detail on those two forms shortly. But those two, to get the buyer to sign it, sometimes the property specific is a perfect one to use just to get started. You're showing 3 properties, just those 3 properties can be on there. In the time period can be 1 day, it can be 1 week, it can be 1 month. You can always extend them. Do it for 1 day. You may not want to work with that buyer after the first time meeting with them. You might say, you know what, this buyer is going to take a lot of work, a
Yeah.
lot of time, and I'm not interested in doing it. And
Yeah.
that's okay. I mean, that's the great thing about being independent contractors. We get to make those decisions just as much as the buyers do. So it might be a form you want to have expire after 1 day. But that's good to have those conversations up front.
Absolutely. I completely agree. So when you are working with a buyer, let's say you have a buyer broker agreement in place, what what else do you need in order to effectively, work with the buyer to be able to purchase a property? What are you looking for from them? So you're not just showing them everything in MLS and hoping they buy something.
Well, I want to make sure that I know if they are going to be paying cash or a mortgage, because if they're going to be getting a mortgage, have they gone through the approval process so that we know what they're qualified for? Because the worst thing that we can do is set somebody's expectations up for a house that they can't afford, or
Correct.
that we find out that we've been working with someone who doesn't qualify for a loan. And again, we're just spinning the wheels. So the more we can find out upfront in that buyer consultation from them, the better off we're going to be able to be, so that we're setting their expectations up as best as possible.
Yeah, I think there's nothing worse or nothing harder to overcome than a buyer, falling in love with a property that they're a day later told they can't afford. It's so difficult to overcome that at that point going forward. So, it's definitely one of the first questions I always ask is, are you paying cash? Are you looking to finance? And have you gotten the pre-approval? And it's best to have the pre-approval done before you go look at any property. Even if the buyer says, "Oh, I'm qualified," I get it. I'm sure you are. However, this day and age, with all the red tape and the regulations and what lenders need to get approvals nowadays, is a lot more than what some buyers are accustomed to or know. And it might be that, yes, everything's good, but guess what? Last week you don't know about it, but somebody stole your identity and now your credit report's all messed up. And so it's best to get these things taken care of before you go look at property. And sometimes that's a harder objection with a buyer than it is getting them to sign the buyer broker agreement. So
That's true. That's
And
true.
the majority of the time when we have an offer that we're sending in that has a mortgage, they want to make sure that they have that pre-approval letter
Yep.
that shows that they have gone through the process, and we submit it with the offer. And even when it's cash, that there's proof of funds. And you'll see that quite often in the confidential remarks, that they want to see that they have gone through, because the seller
Right.
doesn't want to take the property off the market to find out they don't have a truly approved buyer. And and got to make sure that you have a reputable mortgage company that they're working with. Not everybody, this is Florida, and there may be out-of-state lenders, but they may not know all of the nuances of Florida. And so, stay at home.
Yeah, I agree. Working with a local lender can really help to make or break your transaction, especially someone who's familiar with closing on condos. They know what questions to ask. I've heard some lenders from out of state think that the closing date is a suggestion, not a
Mhm.
suggestion, right? So they're aiming for
in
this.
our contract, it's the only thing time is of the essence.
It's really the
so
thing that
Yes.
matters most.
pretty
So
important date.
Yes, yes. Talia, answer to your question, will we be doing another buyer broker agreement class? Yes, I don't have we don't have a time for that, but yes, we will be doing another buyer broker agreement class. In fact, we are going to be working on developing a NABOR specific buyer broker agreement class for CE credit. So stay tuned, but we will be doing other buyer broker agreement classes. I do believe, though, that when these forms were released, there are a few versions of buyer broker agreement classes that are still available on YouTube. I think Sean Gary presented one. I know I presented one. So you should be able to go to NABOR.com and look at the videos, and NABOR, it'll direct you to YouTube, and you should be able to look for a class on what some of these new NABOR forms are that have been released since the NAR settlement. But yes, loud and clear. Also, if you have any suggestions for other classes that you'd like to receive, there is actually a link on the NABOR.com website. I'll send it to you guys, where you can submit your suggestions for new classes. Again, if there's a topic that you're tired of just hearing generic NABOR inspection stuff, but you want to really dive deep into something in NABOR or inspections that are as is versus standard contract, and really want to dive in deep to be able to have that conversation with your consumer, let us know, let NABOR know, because we're happy to prepare those materials. All right, when you are working with the buyer, so we're preparing that information. We know in our NABOR land, we've got a NABOR standard contract versus a NABOR as is contract, and we have various addenda that we can attach to our contract. When we're dealing with the addenda, the idea is to make sure that you as a real estate licensee are not drafting legal language unnecessarily, because I know you see sometimes folks will put in other terms and conditions some language that we say, well, wait a minute, there's already an addendum that exists for that was prepared by Legal Resources, approved by council, approved by the Collier Bar Association. So make sure when you're sort of putting together your offer and your buyer says, well, what if we did this? What if we needed to be a backup contract or something like that? Note that there are addenda for that. And we also have a class on the addendum. There we do on the addenda itself. So I would encourage you to look when you're on NABOR.com website and you go to Realtor Tools and Contracts, sort of scroll through the sort of all of the forms and the list of addenda. You can see a number of them that you may have not used before, but that are available to you. 2 other documents I would want you to take a look at on the NABOR site. One is the timeline of events. I don't know if you guys use the timeline of events or if your transaction coordinator uses it, but it's really a good guideline for you to know what some of the major deadlines are in your transaction and be able to calculate them based on the timeframes in your contract. And that's a good touch point for your consumer as well to say, you know, our effective date is X. Here are the next, 5 deadlines you need to be aware of. That timeline of events form is good. And also the list of NABOR forms. It's just a 3 or 4 page PDF document that says these are the lists of forms that exist in our world, and sort of be able to review them and when they were last revised. Okay, so does anyone want to talk about using the as-is contract versus the standard contract? Has anyone had success using an as-is form in Southwest Florida?
I use them both. I basically, I don't know, not to cut you off, Amy, or anything,
Yeah.
but I use them both. I ask the buyers, I explain both of them, and I let them make that decision. And I tell them, I said, there are some sellers who don't want the as-is contract because they don't want the buyer to have that rescission period to walk away for any reason. However, there are some sellers that it's the only contract they're interested in entertaining. So I think it's a good conversation to have with the buyer and let them make that decision. But again, it is one thing I always check. Confidential comments is common for an agent to put in there which contract the seller prefers, if anything. So that's one spot I'll definitely take a look at first. But have the conversation with the seller. The only thing that's different is the inspection period and the inspection response of that. So it's only the difference in the contracts.
Agreed. Agreed. Amy, what do you think?
Yes, I will use both of them. It'll be dependent upon what we are looking at. To Nick's point, yes, I look at confidential comments first, and you will see that they will specifically ask for the standard contract because they want to be able to go through the entire inspection report because that's what they would like. But if the seller is not going to be willing to make repairs and such, one of the things when my sellers say they don't want to do things is I suggested them putting a home warranty on the property because at least there's some comfort that some of the major ACs, appliances, plumbing, you have a little bit of peace of mind for that first year, and people can always continue to put on a home warranty or a home service agreement. But it takes a little bit of pressure off, I think, of both parties. Now, if it's something that is not covered under the home warranty, like the roof, there's different things, but you've got to look at maybe what is the best way to be able to, and the best paperwork to be able to use for that buyer and for that property.
You guys both mentioned if the seller has a preference of a standard contract versus an as-is contract. And I'm going to venture a guess that most of the time when you see it in broker confidential remarks, it's the agent who says, I'm more comfortable with this form. They haven't actually gone through that process. So, but we know that despite what's in confidential remarks, that agent has to present the offer that they receive to their seller, whether it's an as-is or a standard contract. And again, I know that we in Southwest Florida are in a bit of a bubble where we have buyers who typically want the seller to fix everything all the time, right? And they may want to submit an offer with the standard contract. And I've heard listing agents in Southwest Florida also say, oh, I don't want the buyer to be able to terminate. We'll never go on, it'll never close. And say, well, 95% of the state of Florida actually uses the FAR as-is contract, and transactions close every day, right? So don't be afraid of an as-is contract that gives the buyer the right to walk away. And then what I would say the bonus of using an as-is, because I've used both, but the bonus of using an as-is is you're not debating whether something is cosmetic or defective, you're having a conversation of like, will this work for my buyer? Yes or no?
Yep.
And if you've properly prepared the seller for the possibility that the buyer will ask for something, even if it's as is, seller's like, okay, you know what? I know I'm not under an obligation to do anything. I'm prepared. They're going to ask me for something. Fine. At this purchase price, it makes sense to move forward with that particular request or with that repair or credit. You guys want to talk about effective contract execution? So making sure we've got an effective contract.
And Erin, can I just point out one other thing too? When you have that as-is contract and the inspection comes through and there is something wrong, maybe termites were discovered that wasn't disclosed or that. I've had many times where buyers will go back and they will still ask to have something repaired. The seller still doesn't have to repair it. However, now the seller has to disclose it to the next person because it now is a defective item. So you
Yeah.
have to explain that to your seller saying, you know, this issue is not going to go away. Now
Right.
everybody has to know. We have to update the seller's disclosure. And so it's still that bit of that negotiations and all that that can still be happening. Because sometimes people, I had a customer who, when they pulled out the AC vent, they found out that they had termites there. Boom. Had it all taken care of, and we agreed to terms and the property closed. So don't be scared of it.
Agree. And I
Okay.
really think that our buyers and sellers can handle whatever is thrown at them in a transaction as long as their expectation is properly managed up front, right? They just know what to
Yeah.
expect. Sellers, be prepared for the possibility that a buyer is going to ask for repairs. Don't worry, you don't have to make
Yeah.
any repairs.
Communicate with
Right.
them and be transparent. Right.
Be
Mhm.
transparent. And
Yeah.
again, that to me is one of the benefits of a buyer working with a real estate agent as opposed to trying to go it alone, because they need someone to guide them through the inspection process. They need someone to explain to them, whether something, if something is defective, put the buyer in contact with an appropriate contractor to find out more information and that kind of thing, and help to be the source of information to help those buyers. Okay, just one point about effective contract execution. The reason I bring it up is I want to make sure that if we are using an addendum to contract, that is effectively incorporated into our sales contract. So I've got an
Check
offer.
the box.
I've got to check the box, and attach the darn thing to the contract, right? So our
Yes.
sales contract with the condo addendum, check the box for condo, attach it to the sales contract, submit it over, and then make sure when the seller countersigns or counter offers that that addendum is still attached to the contract and the box is still checked. If the seller returns a sales contract, let's say I've submitted an offer, I've checked the box, attached an addendum condo to the contract, and the seller responds, removes that condo addendum or whatever addendum from the contract and sends you back just the signed contract, no condo addendum. Do I have a fully executed contract? No, I have a counter offer. It'd be very silly of him to remove that condo addendum to contract. So make sure, again, what you send out is what you're receiving. And understand that if the seller does submit a counter, that you're sort of having your buyer countersign to acknowledge that that addendum is no longer part of the sales contract. Beyond the scope of
I
today's
think one of the
presentation,
other,
yeah, go ahead.
one of the other things that, and I see this too, when you're in that counter offer, it's not just the signatures or just the initials, but it's the initials and the date, because when you're trying to figure out what your effective date of that contract is, if all of a sudden now your seller is countered to the buyer's initials, but doesn't date it, and it's maybe a day already later, you have to go back to what that last date is on that contract. And so
Yep.
you may be doing your buyer a disservice because you may have just cost them 1 or 2 days. So we
It's what-
have to make
yeah.
sure that it's not only initial, but dated as far as the
Yep.
changes are concerned.
Yes. So check the box, attach the addendum to the contract, counter offers, signatures need a date, initials need a date, making sure everything is signed, dated, initial dated, especially in NABOR land, the last date that appears next to a signature or initial is the effective date. And that's why Amy's saying that if you have subsequent initials that don't have a date on it, you're going to have to go back to whatever date appears in the contract and that's defined as your effective date, which means your buyer could be 2 days already into their inspection period, or their deposit could be due tomorrow and they thought they had more time. So make sure that they're managing that timeline. And what's the best way, Nick and Amy, for you to get on the same page as the other side as to your timelines and deadlines? And when
So
is
what
that
I-
important?
So
Right
what
away.
I do, once I have what I've deemed to be the fully executed contract, I send the other party, an email, whether it be the buyer's agent or the listing agent, whichever, the opposite of what I'm doing. And I say, here's what I've got. Here's the effective date. Here's my deposit schedule. Here's my inspection. Here's my financing. Here's my closing date. And I say, I match with them. I say, is this what you show as well? And just to make sure. And if there's a discrepancy, let's get it hammered out right now on day 0, day 1. Where are we at? What did we miss? Any confusions? Okay, let's get it cleared up. Yes. Okay. Now we're on the same timeline. Everybody knows the deadlines. And then I reiterate these deadlines to my buyer or to my seller, whoever I have, and make sure again that they're aware of it. And I keep track of everything in my own calendar personally. So deadlines coming up and stuff like that. So I know about them. But no, I agree. You got to just make sure because, again, I mean, especially for our contracts, when a deadline falls on a weekend or a holiday, it extends automatically to the next business day. And some agents forget that part. They think the inspection period ended on Saturday. Nope, it follows to Monday. So it's, those little things, again, you just want to, it's not saying you're right or wrong. It's just saying, let's make sure we're on the same page and make sure we're both talking about the same thing to our customers and not giving our customers incorrect information. Because again, that makes it more difficult to go through the process.
Agreed. And it's better to get on the same page early while everyone is still happy. A seller is relieved to be under contract. A buyer's excited that their offer is accepted. Don't wait until there's an issue. And then folks are going to be fighting over that deadline. I want to answer Carrie's question. If you guys have any other questions, go ahead and put them in the chat and we'll answer them as we go. But I think this is an important, Carrie, your question is the same question that so many folks have. That let's say the seller at the time of listing hasn't agreed to pay buyer agent compensation. So there's no broker compensation agreement available, doesn't exist, or just the listing agent won't for some reason provide that broker compensation agreement. What tool could you use? So the NABOR addendum to request a credit from seller to buyer towards the payment of buyer broker compensation is that NABOR addendum - concession. I want to show you guys because if you aren't familiar with the NABOR form or you haven't used it yet, I think it's a good opportunity to have that conversation. So hopefully everyone can see my screen. Let me scooch this. Can someone give me a nod that they can see my screen?
Yep, we can say.
Okay. Wonderful. All right. So addendum to sales contract concession. So this is a credit from seller to buyer. So seller and buyer regarding a particular property. Seller shall provide a credit to buyer at closing as follows. A credit, the first checkbox, and the amount of blank or blank percentage of the purchase price towards closing costs and prepaids. That's one. A credit in the amount of blank or blank towards buyer's broker's compensation. That's another checkbox. Could you potentially have both of those boxes checked, Nick?
Yeah.
Yeah.
Yeah,
So
definitely
you
could.
could have X dollars towards closing costs and prepaids. You could have Y dollars or Z% of the purchase price towards the payment of buyer broker compensation. So again, this is a math problem that we're solving. Sellers providing credit to the buyer either towards closing costs and prepaids, or if it is something that we want to be above the IPC limit, the interested party contribution limit, it would be towards buyer broker compensation.
And again, this, going back to the beginning is, finding out is your buyer paying cash or are they financing? And if they're financing, do they need credits from the seller for their closing costs? Because if they do, then you have to be mindful of what is the maximum credit. Conventional, it's 3%. FHA, it's 6%. So if you're trying to have the seller give buyers closing cost credits that they need for their actual closing costs, plus your compensation, you need to know that in advance because you might have to use a different form because the credit might exceed the limit that's allowed per the lender. So in a conventional, if a buyer needs 3% for closing cost credit that the lender says, look, I need this for them, then you got to use that form for their closing costs. But your compensation probably needs to be on a different form because they're going to be maxed at their credit concessions.
Sure,
So-
sure. And the reason this this sort of specifies towards buyer broker compensation is because the preliminary guidance we have from Fannie and Freddie says, listen, if the seller is providing a credit for something that is customarily paid for by the seller, then it can be above and beyond those IPC limits. We want to make sure that we're specifying what the credit is for. If you have a buyer who's seeking financing and you're hoping to use this addendum, there's certainly nothing wrong with providing a copy of the addendum to the lender and saying, hey, does this work for what the buyer is looking for? And just get them to sort of preliminarily approve of this form. And so this is, again, an addendum to contract that is designed to be attached to the contract. Check the box.
Check the box.
Check the box, attach it to the contract, submit it with the offer. Those are very important. Check the box, attach, submit it with the offer. And that if the seller agrees, great, they're going to countersign this addendum and date it and return it with the sales contract. I've seen this used also when a buyer is submitting an offer and maybe the buyer's agent wasn't able to get a hold of the listing agent to find out if there's a broker compensation agreement, or the listing agent wasn't willing to share that information, but the buyer really wanted to make sure that they weren't going to be on the hook for paying out of pocket what is due to their buyer broker under their buyer broker agreement. They want to make sure that was offset by the seller. They can use this addendum to sales contract concessions as a means of making that request. And if I'm the seller and I already have this compensation agreement signed, or I've agreed in my listing that the listing broker is actually going to be paying buyer broker compensation, and I receive a sales contract that I'm initially excited about, but has this addendum attached, if I'm the seller, I'm going to say, well, wait a minute. Why are they asking me for more money? Why are they asking me for a credit? Don't I have this as part of my listing agreement and compensation type of agreement? And so in that instance, the seller may counter the contract, maybe not include this concession addendum, but provide that broker compensation agreement that has already been agreed to as evidence that the obligation to pay that buyer's broker is going to be offset by either the listing broker's contribution or the seller itself.
Yeah. Or if the buyer broker agreement that you have signed is for more than what the seller is currently offering through the listing broker, you could use this form to get the difference, requesting the additional difference to be paid as well.
Agreed. And while we're talking about the addenda to contract that deal with compensation, I want to talk about this one as well. This is addendum to sales contract compensation. Think of it as compensation contingency. So the buyer's making their offer contingent upon receipt of one of those compensation agreements between the listing broker and the buyer's broker, or between the seller and the buyer's broker, showing a particular amount of compensation that the buyer's broker is going to be receiving from somebody other than the buyer to offset that buyer's expense.
Yeah.
So we're saying this contract is contingent upon seller delivering to buyer within X number of days after the effective date a copy of that compensation agreement upon the following.
And again, we need that compensation agreement now because it's no longer automatic through the MLS system as of August 17th.
Correct. Yes. And I've had some folks say, well, can't I just get a text message from the other side saying they're going to pay the compensation? And I say, jokingly, only if you want to produce to a judge all of your text messages showing that conversation. Most folks would just prefer to present a document with an enforceable mechanism. So just know that this is, again, the addendum to sales contract that allows the time for the brokers or the seller and the buyer's broker to enter into a binding compensation agreement after the effective date of the contract. And I think it's a very helpful tool.
And as I mentioned, when we first switched over to the buyer side is, both of these two forms, it's good to show them to your buyer. If your buyer's struggling to sign the buyer broker agreement, it's okay to show these two forms to the buyer, and say, look, here's the two different forms we're going to use to try to have the seller pay the compensation so that you, Mr. Buyer, are not paying it directly. Yep. So, give them two options.
Absolutely. I think that's a fantastic tool. Absolutely. And even show them what the broker compensation agreement looks like, there's a, so just want to recap in our NABOR.com Realtor Tools, NABOR contracts. You can see the list of all of the NABOR contract forms effective as of January 1st, 2025. We have so many forms that are beyond the sales contract and the addenda, but just know that they are available for you. So if you have any questions, look there before you start to type in some legal language and other terms and conditions. And then here, as I mentioned, the reference materials regarding the code compliance, energy efficiency, those kinds of things. So those are available for you. Are there any other questions in the chat while I've been sharing?
One last thing, just because I know it comes up in a lot of different training and classes. So a lot of questions is, when do I need the buyer broker agreement on this, on a listing side? And the answer is, for an open house, you do not, per the settlement. And again, your broker might have different rules, so make sure you check with your broker, but to comply with the settlement, you do not need a buyer broker agreement to show an open house. If you're hosting the open house for your buyer, for your seller, if you get a phone call from a buyer who says, I want to see your listing, same thing. You do not need a buyer broker agreement to show that property. You are working for the seller at that point. If the buyer wants to make an offer, that's a different situation, different scenario, but you do not need the buyer broker agreement to show your own listing to a buyer because you are working for the seller at that point still.
Great. Good. Other questions? The question was, can we give the direct link to the forms in the space? I can give you the link just so you can see the web address, but you're going to have to sign into nabor.com to be able to access it, because it will sit behind your, as a member benefit to be able to access those forms. What else? Oh, there's a FAR question. It's a bonus question. It's, all right, I'll answer it. The FAR seller's disclosure, the Florida Realtors form that is used for the seller's disclosure in FAR land, does not have the same acknowledgement language that the NABOR seller's disclosure has with respect to the condition of the property. In any event, when you're talking about the seller's disclosure and you're using an as-is contract, whether it's a NABOR as-is or a FAR as-is, that buyer's acknowledgement of receipt of that disclosure does not matter when it's an as-is contract, because a buyer can always ask for anything.
Yep.
Or nothing, or a credit or a stain in the carpet to be addressed, or whatever the buyer decides that the property is not suitable for their purposes. So when it comes to an as-is contract, the seller should disclose latent defects that exist on the property, but it doesn't have the same impact under FAR standard or either of the as-is contracts as a means of saying this object is no longer defective. The way I think to address that in the sales contract is, and I'm not confident that it would get you super far, but if the seller says, I'm disclosing that the window is broken in the guest bedroom in my sales contract, and I have no intention of fixing it, put it in the sales contract, seller shall have no obligation to fix the broken window, fine, but the buyer still has the right to terminate the contract within the due diligence period for whatever reason, if the property is not suitable for their purposes. So I hope that answered your question, iPhone 32. Let us know. If you have any other questions, please put them in the chat, or you can send us an email. We will have a recap email with a little handout checklist of the things that we talked about today. We'll send it to Jeanette. If you have any follow-up questions, let us know. And again, any other topics you'd like to know more about from a NABOR contract perspective, let us know. I'm actually going to drop in the link, a couple of links for you. The NABOR suggestions for NABOR classes. There is a place where you can submit those suggestions. I'll go through that in the link. And also the business partner directory. Again, you guys are excellent sources of sources. So just consider looking in the business partner directory when you're looking for suggestions of folks to refer your customers to. And again, we'll put all this information in our recap handout. You guys are great.
And Erin, one other thing that I just want to mention before we sign off, we've been talking about addendums all day, but we don't talk about amendments. And so I had somebody ask me, how do I explain it? And so when I am writing up an offer and I'm adding any of these terms and conditions, it's an addendum because I'm adding it. Once we now have a fully executed contract and there is a change, I, in my brain, am mending, I'm fixing something. So it's an amendment to the contract. Florida Realtors doesn't have amendments. They only have addendums. So it's interesting to know that sometimes we have to make a change, closing date, We have forms for that, but you'll see that the terminology is different on that depending upon what stage you're at in the contract.
That's why NABOR forms are better. They're more accurate.
Ooh, Nick. Oh. So yeah, so the Florida Realtors, Florida Bar contract form universe is the standard contract, the as-is contract, and all of the addenda. Rider A through GG does not have a blank addendum because they don't want realtors creating legalese. It doesn't have a blank amendment because they don't want realtors creating legalese. And so the idea is they want an attorney to draft the language for an addendum, a miscellaneous addendum or miscellaneous amendment to contract. But Amy, you're right. We do have a number of amendments to contract forms for providing particular notice, waivers of financing contingency. We prepared these documents so there are tools for you to use so that you don't have to create the language. I also dropped a link to the NABOR videos in there. And thanks, guys.